Thurman and Ms. Jones, pay particularly close attention because I'm charging you with drafting an order consistent with the court's findings for review and collaboration with the state. Stating the obvious, the COVID-19 pandemic has caused unprecedented economic harm in Nevada. Its scope, its depth, its swiftness has never been seen before in this state or any other, and hopefully the likes of which will never be experienced again. Its effect on Nevada has been especially devastating, created by really a perfect storm consisting of many things, including but not limited to, number one, already decreased DETR and Employment Security Division staffing levels resulting from federal funding calculations made during Nevada's robust economic times. That's nobody's fault. That's just the reality. Number two, a bit of and these are the court's words, nobody actually said it, but the sense the court gets is a somewhat outdated or antiquated, hardware or software system being utilized to run the usual unemployment insurance program, website and attendant, computer and technological needs. Third, the need, therefore, to create from scratch a pandemic assistance benefit administration program rather than, again, this is not a technical term, it's a lay term, but stack the new program upon or within the existing UI program. The decision to do that appears to been made by senior administration at DETR or ESD. And as the court will jump ahead to conclusions of law, there's no abuse of discretion that the court would surmise from that decision. Number four, the nature of Nevada's primary economic driver, gaming and tourism, and the resulting almost total shutdown of huge sectors of the economy based on justifiable concerns for public health and safety. Finding of fact number 5, court takes judicial notice of the fact that there is an especially large English as a second language workforce with attendant difficulties navigating either or both of the UI/PUA websites. Those websites appear to be user-friendly to an extent, but can be a bit confusing, particularly to someone who's not familiar with all the language and all the requests being made of them. 6, the call center performance has experienced serious challenges. And while there's enough blame to be distributed about, the reality is the challenges were no doubt aggravated by the urgency of establishment, which resulted in significantly shortened agent training periods. Does that, as an aside, does that relieve a representative of showing compassion and respect to those that call? Of course it does not, but it can as well account for some of the gaps in knowledge and ability to directly assist, as we would expect a group like that to be able to do had it had additional time to prepare. 8, the nature of the work histories of many of the so-called gig workers, hundreds of whom may reside outside yet work inside Nevada, or who worked intermittently, or who tried to work somewhat and did not completely stop working during the pandemic. 9th reason why this factual scenario created the perfect storm in Nevada is the likely presence of some imposter or social media robotic influencers designed not to share genuine experiences for collaborative benefit, but rather to unduly pressure, harass, or attempt to intimidate state employees and or policymakers to act in a way consistent with their view. 10, the time it takes to train new hires or repurpose hires from within ESD to be in a position to provide clear, competent, knowledgeable assistance to those seeking information or clarification of their benefit claim status. And confirming next what the special master suggested, the sheer number and volume of applicants for benefits indeed caused a tsunami of those seeking help for which no state, particularly a state with all these other factors I've just indicated, could have been properly prepared. I might add as well, it was not discussed today, although it's in the briefing. Another reason this is a particularly challenging time for Nevada is the CARES Act administrative funding component apparently requires prepay by the state actor, who then seeks reimbursement. And while that's certainly appreciated by those who can use that bucket of funds for administrative purposes, well, it does require upwards of millions of dollars to be outlaid by the state, apparently, in order to be in a position to request recoupment. And if you're already running thin with budgetary constraints and staring down extremely large shortfalls, I'm sure it caused a lot of concern and difficulty in the state being in a position to pre-fund the CARES Act administration component. Those are challenges that made the effect on Nevada especially daunting. There are other findings, though, the court wants to put on the record. The court finds that the CARES Act and the unemployment benefit component is designed to be remedial. It's to remedy the pain and economic harm that people in each state are experiencing that are legitimately pandemic related. That's one of the reasons, as the court understands, that the application for benefits is allowed by self-attestation. Somebody need, among other criteria, swear under penalty of perjury that the information that they are supplying is accurate and honest, as opposed to, the dual opportunity to verify. Of course, there's no employer to be at the table to protest any inaccuracies, but so the reality, particularly for part-time, piecemeal, or gig workers, is that self-attestation is how it has to be. But nevertheless, the mere fact that this law allows people to apply for benefits on their own word is itself evidence that it was designed in a way to assist people as quickly and thoroughly as possible in their time of need. The CARES Act apparently, with respect to unemployment insurance benefits, has eliminated the requirement of searching for work during the benefit period. That's, again, a product of two things: the reality of the difficulties and potential health and safety concerns of searching for work at this time, and also the need to distribute benefits as promptly as possible. And then finally, believe the usual unemployment insurance program requires either a 1 or 2 week waiting period. But in any event, I believe the PUA program has done away with the waiting period, all suggesting to the court that thoroughness, but yet swiftness, is the goal. The court finds, as a finding of fact, that this particular act is particularly vulnerable to fraud. Other states have experienced it in greater number and amount than Nevada, and the threat of fraudulent applicants is real. Guidance, legislative history, and answers from the Department of Labor to questions posed by the special administrator all emphasized the seriousness with which the United States government takes the state's responsibilities to take due care to limit and circumvent fraudulent applicants and safeguard the people's money to ensure it goes to the right place. The court finds that the efforts of Administrator Ga and her senior staff have showed extraordinary vision and leadership in extremely difficult times, as well as former Administrator Korlick, who I'm aware no longer works for the department any longer, but who worked, no doubt, extremely hard under difficult circumstances to stare down this tsunami. Those lead us up to the final finding of fact, which is that benefits have been delayed more than they should have been for many people. And we'll talk what we're going to do about that in just a moment. Conclusions of law. And Mr. Thierman and Ms. Jones, there's a very good chance that this court's decision will not be the final stop in judicial review of this dispute. So I'm reminding the petitioners here, the plaintiffs, that if there are issues with regard to standing or mootness or jurisdiction, these are arguments that you've advanced and convinced the court at this stage tilt in your favor. But the court notes that it's an extremely close call, but nevertheless, the court concludes, issue of law number one, that the court has jurisdiction to hear this matter and that the claims are not moot. The court will note Mr. Thierman's argument that some claims are capable of repetition, but yet can evade review, because by the time review comes, the issue's been resolved somehow, but yet they can resurface again with other people, other entities at other times, and that fact can make what otherwise might be an unripe case ripe for decision. The court finds that these claims fall into that bucket. So the court believes, as conclusion of law, that it has the ability to move forward with this case and does so. Borrowing from the briefing, Nevada Revised Statute 34.160 empowers a district court to issue a writ of mandate directing, in this case, another branch of government to perform an act which the law especially enjoins as a duty resulting from an office. Now, in the usual phrase, enjoin means stop, but in the way it's used under NRS 34.160, it means to move forward. So the statute gives a district judge the authority in certain cases to issue a writ, issue an order directing a state, or in this case, a department of the state, to move forward. When should a court exercise its discretion to do so? Well, the law is clear. Writs of mandate are properly issued when there is a clear present duty to act. The court is citing from the Newman case decided by the Nevada Supreme Court in 1981, found at 97 Nevada Reporter 601. That's still good law. That's still the law of the state of Nevada. Furthermore, courts may issue writs of mandate where there is not a plain, speedy, and adequate remedy in the ordinary course of law. Court finds that applies here. There is no other approach petitioners could take to obtain the relief that they seek, at least under the time periods involved here. Court notes that writs of mandate are extraordinary remedies. Writs of mandate are normally only appropriate where the relevant facts are not in dispute and a clear question of law is presented. Now, certainly, importantly to our discussion, writs of mandate should not be issued in order to control government's discretionary acts unless the discretion is abused or exercised in an arbitrary and capricious manner. Petitioner, in this case the plaintiffs, as I mentioned at our last hearing, have the burden of demonstrating that that the issuance of a writ of mandate is warranted. If they don't meet that burden, or if it's 50-50, the writ does not issue. Well, what does arbitrary and capricious mean? In our context, really a pretty good definition of that is an agency, in this case DETR's actions or decisions while based on consideration of relevant factors, suggests there has been a clear error in judgment. District courts may reverse or change an agency's determination if an agency relies on impermissible factors, fail to consider an important aspect of the problem, offers explanations for its decision that run counter to the evidence, or is otherwise so implausible that it could not be ascribed to a difference in view or the agency's expertise. Well, where does that leave us? Does the court find that the that DETR's actions have been arbitrary and capricious, or that it has abused its discretion in the manner in which it's administered its legislatively required responsibilities? The answer to that question is somewhat. In fact, to a large degree, the court thinks it has done just fine. It has exercised its discretion properly, made decisions rationally based on the evidence before it, used its expertise to come up with the best solution. I'll give you an example. Standing up the appeals process protocol after the claims system was established and claims are being reviewed and paid or not, adjudicated, that makes complete sense to the court. That's an example of the exercise of discretion that was wholly appropriate and proper. But in 3 ways, the court finds an error in the manner in which DETR has approached this. The first way is somewhat modest, but nevertheless important. And I apologize to all involved that it's taking the court so long to identify its decision and the basis therefore, but as we all know, this is a fairly involved case with a lot of moving and fluid parts. So I apologize for the delay. Guidance from the Department of Labor, and I'm referring to pages 80 and 81 of the Special Master's report, provides examples of what may constitute a qualifying COVID-19 related circumstance for PUA eligibility. So we're way down here, because obviously to get benefits, you need to have a qualifying COVID-19 related circumstance. But these are examples. One of the examples on page 81 is an individual works as an independent contractor with reportable income and is either unemployed, partially employed, or unable or unavailable to work because the COVID-19 public health emergency has severely limited his or her ability to continue performing work activities and has therefore forced the individual to suspend such activities. For example, a driver for a ride-sharing service may qualify for PUA benefits if he or she has been forced to suspend operations as a direct result of the COVID-19 public health emergency, such as if an emergency state or municipal order restricting movement makes continued operations unsustainable. The court understands that DETR has been construing someone who drives for a rideshare program ineligible if they don't completely suspend their activities. The court believes that's an error. The court will construe suspend to mean, or have the functional equivalent of, substantially interfere. To do otherwise, in the court's estimation, would lead to an unfair and unreasonable result. By way of an example, a Lyft driver who works in Clark County and the hotels and casinos have been shuttered, at least they were, or whose operations have been significantly scaled back as they are now. Well, if they completely suspend operations because of COVID-19 and orders of the executive branch, they might otherwise qualify. But if they work a few shifts, a few hours a day, 10, 15, 20 hours a week, well, according to the DETR's interpretation of this guidance, they would not qualify. I think that's error in judgment, because that would penalize somebody for trying to support themselves or their family. Or, for example, take a senior to a doctor appointment who doesn't have another ride. Take anyone to go see a relative or loved one. Go shopping. Take someone to go food shopping. I mean, we are not going to penalize people under the CARES Act because they try to maintain some level of subsistence income while they wait for the economy hopefully to right itself or otherwise have benefits available. So to the extent that benefits have been delayed or outright refused because of the determination by DETR that suspend means completely suspend, the court finds that error and an abuse of its discretion, such that a writ will issue ordering payments to be made to people that otherwise would qualify and fall in that category. Again, this is part art and part science, but the court provides its definition. Suspend is the functional equivalent of substantially interfere. I think that's consistent with the goal of the CARES Act. That's number one. Number two, the court believes that the United States Supreme Court case, California Department of Human Resources versus Java, 402 US 121, which came out in 1971, and guidance from the Department of Labor, for which expands its view of what that case means relative to unemployment benefits. The court believes that to the extent DETR has started benefit payments to an applicant, then stop them for reasons other than the applicant did not weekly file, the applicant has earnings in excess of the allowed, not allowed, but in excess of that which would otherwise qualify the applicant for benefits, or the DETR has clear and convincing evidence of fraud, then payments may not be stopped. The court believes that a fair reading of Java suggests that to do so would be misconstruing the law by DETR, and that ends today. DETR is not to withhold benefits that have already started, absent one of these three reasons, or otherwise after a hearing and an opportunity for the beneficiary to state their case and respond to the reason that the state would like to stop their benefits. Lastly, and I'm going to need a little bit of clarity here because I thought I understood it, but now I'm starting to rethink this. The FPUC payments, as the court understands it, are otherwise available to someone who is receiving the UI or is receiving the PUA benefits. And therefore, if somebody qualifies for one or the other, those payments should be layered on top. Mr. Ott, is that what the law provides as the state understands it? You're still on mute.
Sorry, that's correct, Your Honor. If they're eligible for either program, they get paid FPUC.
All right, so again, so this is the third part of the writ order that's being, the writ of mandate. The court orders that the FPUC payments be made to parties that the state believes would otherwise qualify for one or the other of the two programs. Now, what does that really mean here? That means that they have, of course, this goes back to when somebody qualifies for the benefits in one or the other program. But actually, I'm gonna walk back that part of the writ. That all goes to eligibility and who receives a favorable determination, and how can the court order FPUC payments when we don't know where they are. So the writ will issue on the two issues that I've just stated: the Java inspired portion of the writ and the court's reasonable reading of the Department of Labor guidance on people who are trying to earn something. They should not be penalized because the court doesn't believe suspension should be interpreted that way. Now, the order will deny without right to renew the other issues sought by petitioners. We're going to go through in greater detail some of this shortly, but we're going to have a hearing unless somebody is absolutely unavailable. Thursday, July 30 at 10 a.m. And the court wants to see some level of response between now and then from the state to issues like the UI-PUA backlog. It's unacceptable to the court, but not quite. The court is not quite moved to find an abject abuse of discretion or arbitrary and capricious conduct by the state, but we're edging that way, that people are in this no man's land where they're being blocked from benefits in either one. So I'm hoping that the state can come forward in 10 days and educate the court on steps it's made to unblock that group of people. That's number one. Number two, what steps DETR has made to move the first filers to the front of the line, or to the extent you already are doing that, what progress has been made. Number three, the issue of people who have sought benefits apparently from February 29 of this year, leap day, through March 5th. Apparently there were a group of people that the evidence reflected were not eligible for payments because the first confirmed case of COVID-19 in Nevada didn't occur until later. But the court is persuaded that DETR, if you're not already doing so, needs to look and see the reason why those people's income appears to have been affected, particularly if they were working with people or traveling to or dealing with businesses that had been affected already. So the mere fact of Nevada's first confirmed date is of no moment. It's relevant, but it doesn't end the story. I would like, when we meet on the 30th, to hear from the state positive developments on the UI-PUA dichotomy, which the FPUC payments on top of that will hopefully flow as well. I would like to hear what is being done for the first filers, and I would like to hear what is being done for those who have applied for benefits for the first week of March, as I've just stated. To the extent the relief sought by petitioners exceeded what the court has just said, the court is not convinced a writ should issue. The court would like to keep the special master on at least until the 30th, to be available as a resource or facilitate educating the court on what's being done over these next 10 days on these three groupings. Now, I'm not suggesting, Mr. Guanasso, that it become a 60-hour-a-week project like it was or more. I'm expecting a much marked decrease in your time, but I'd like you to be available as a resource, occasionally interface with both sides, and so that you can be on the hearing on the 30th and answer any questions that the court may have. With respect to when payments need to begin on those issues that the court has granted the writ, the answer is within 5 calendar days of the order being filed in this matter, consistent with the court's oral decision. I would like to have a draft of that order by tomorrow afternoon, which means Mr. Thurman and Ms. Jones, you have to create it, submit it to the State Council for review and comment, try to work with them so that it accurately reflects the court's decision, at least on the form of the order. Obviously, the state does not agree with with the court on the substance because they suggested no writ should issue at this time. But in terms of the form of the order, I'd like for you to reach consensus. If you cannot, then Ms. Jones and Mr. Thurman, you submit but do not file by email to the court your proposed order. The state is to submit but not file yet. It's objections to or competing proposed order. The court intends to look at it tomorrow afternoon and Wednesday morning and file the order by close of business on Wednesday, the 22nd. Payments will then be due pursuant to the order embedded in the writ within 5 business days, which would then be Tuesday of next week. If there's going to be appellate review sought of this court's order, that gives the movement time, either side if they feel aggrieved. The next hearing, make no mistake about this, it's not an order to show cause a hearing. It's not a why should the state be held in contempt for failing to abide the court's order hearing. It's a I want to see progress on the issues I've identified, and I'm expecting there to be no issues with what the court has ordered, which will be filed on Wednesday of this week. Of course, we can use that time on the 30th if there are questions, if there is feedback, if there is confusion. The court will address it at this time, and if necessary, amend the order. But doing nothing in response to the order, that would be a problem. I'm not anticipating anybody would knowingly violate the court's order. Let me start with plaintiff counsel. Do you have any questions with what the court has just identified?
This is Mark Thurman. So am I to understand, though, it's a final appealable order as to the issue that you're putting on for a hearing anyway, or is it not? In other words, you said you're edging towards a writ maybe in the future if there's no fixing of the UI PUA conundrum. Is that a final appealable order now, or do I wait until we hear how close to the edge we get?
That's a decision. That's a decision for you to make. And I didn't use the word fixing. I said I want to see progress. In another subset of my job description here, I deal with criminal justice matters, and I often speak to people and say, I'm not looking for perfection, I'm looking for progress. I would say here that that's probably what the court's looking for between now and the hearing on the 30th. So I'm holding in abeyance the court's decision on the writ, unless you want the court right now to affirmatively say, Mr. Thurman, it's denied, in which case, if that strategically is what the petitioners are asking for, and I won't put you on the spot, you don't have to make that decision right now. You can advise the court by virtue of the proposed order that you want to submit. If you want the court to outright deny it, I'm assuming the state will not object to that, and then you can decide what to do. But you don't have to decide right now. Any other questions, Mr. Thurman?
No, and no, thank you, Your Honor. I didn't. I could answer right now. I probably would. I don't want to deny it. because I'm not sure what my appeal rights are without a total dismissal anyway. So,
Okay. All right, Mr. Ott or Mr. Whitney, any questions about what the court is ordering at this point? I can't hear anyone talking, so if you have a position, please.
Sorry. A couple questions, Your Honor.
Go ahead.
For the purpose of appealable issues, have you made a determination regarding class?
Well, I'm not certain. No one has asked the court to certify a class, and nor is the court doing it sua sponte. I am finding that that this case is not moot merely because most of the named plaintiffs have had their claims. I'm not sure if adjudicated is the right word. They've begun receiving benefits, but many of the issues here can affect them. And to some people who are not currently plaintiffs, the issue can be repeated, but evade appellate review. So that's the way I'm going to answer your question. The court believes it has the authority to order as it did, and has done so. But go ahead. What else?
Second question, Your Honor. At the last hearing last week, we had a special master and appointed, and we were responding to one writ, and then there was an amended writ, and then there was another filing. You set out an agenda for the next hearing on July 30. I want to know if that agenda is subject to further amendment. Should the writ be further amended, or should further pleadings be filed, or should we be focusing on these three issues, notwithstanding whatever else gets filed?
Here's the answer. I want the state to focus on the three issues the court has just identified. If there is something the petitioners file, the state has the opportunity to respond, but it's not right now set for a hearing. The hearing will be on the status of progress, if any, the state has made on the three issues the court's identified that the court has concern about, and to the extent the special master can hopefully verify factually the progress that's been made, and then to respond to any questions with respect to how the court's order expressed on the record now and memorialized Wednesday is being followed. That's what the court envisions. Now, if the state wants to respond to some or all of the recent filings by the petitioner, you're certainly welcome to do so, but I don't yet have that set for hearing. Mr. Guanasso, do you have any questions of the court at this time?
No, Your Honor, thank you.
All right, with that, we're going to have to end this. The court has to jump on something else. Appreciate everyone's professionalism. I look forward to seeing you on the 30th. Mr. Thierman, and please submit an order, hopefully a collaborative, agreed upon form of order, if not your proposed and the state's proposed, or just objections to the petitioners, and the court anticipates following the order by Wednesday and requiring payments to begin consistent with that order no later than Tuesday of the following week. With that, the court will be in.
Your Honor, you, in the beginning of the hearing, you said you were going to, or you were advising the clerk or the reporter to basically give you rough notes, and I presume, and you actually did say to the parties too.
Yeah, so Ms. In, please, when ready, please get a rough draft of the transcript to the court. I'll look it over and, assuming no issues, likely direct you to get it to the parties as well. But please also prepare a final of the transcript at your earliest convenience. All right, with that, the court will be in recess. Thank you, everybody.
Thank you, Your Honor.
Thank you.
You're welcome.